Call to order the November 19th meeting of the Victoria Planning Commission. Our first order, anybody has any cell phones, can you please silence them now? All right, great. Our first order of business is approval of meeting minutes. And my question is this, should we approve them separately? I guess they're two separate ones.
It doesn't matter. Whatever y'all want to do, y'all can
Okay.
approve both of them.
All right, we'll approve both sets of meeting minutes.
So moved.
Second.
Okay, so we have a motion by Mr. Woods and a second by Ms. Wyatt. All those in favor say aye.
Aye.
Any- No opposed? Okay, the meeting minutes passed. Next item is citizens' communication. If anybody wishes to address the commission on something not on the agenda, please do so now. Okay, I don't see anyone there, so we'll go ahead to the next item, and that's development reviews. You can go ahead, Mr. Charles.
Good evening, Commissioners. First item on the agenda is for Tremont Apartments. This is a variance to Section 21-64 of the City Code, which states the following. Building setback lines as specified in Article 3, Division 1 Development Guidelines shall be provided for every lot. Such lines shall be drawn on the preliminary and final plats. When public utility easements in excess of the setback requirements exist or are established on a lot, the building setback line shall be adjusted to conform, at a minimum to the easement dimensions. No building permit or building moving permit shall be issued for a building which will encroach any minimum building setback lines, except the owner of two adjoining residential lots may obtain a building permit to construct a house or structure across the interior building setback lines. The Tremont Apartments is located at 3104 Sam Houston Drive and 104 Abbey Street. It is 5.974 acres, being a Tract 1 of 03230 SA and MG R Abstract 323. It is a multi-family residential. The site has long been developed as apartments. The owner wishes to construct 78 carports over existing parking spaces. The construction of any new structure requires this property to be platted, as it was developed prior to the subdivision regulations and is an unplatted lot. Current regulations require a property to be legally subdivided prior to the issuance of a building permit for any new structure. The owner is requesting a variance to the requirement that the setbacks be a requirement of any new plat to construct the proposed carports and the required setbacks. The City of Victoria Code of Ordinance Section 21-64 requires building setback lines on all plats. The applicant recognizes platting will be required to obtain a building permit for the proposed carports and is seeking a variance to remove building lines from the required plat, which is to be submitted at a later date. Section 21-16 allows the Planning Commission to recommend approval of variances to the City Council only in cases where it makes specific findings that request meets the following criteria. First criteria is the granting of a variance will not be detrimental to the public safety, health, or welfare, or be injurious to the surrounding property. Second is the granting of a variance is not based on a hardship which is self-imposed. Third is the hardship is not based solely on the cost of complying with regulation. Fourth, the granting of the variance will not have the effect of preventing the orderly development of other land in the area in accordance with the provisions of this chapter. And finally, there are special or unique circumstances or conditions affecting the land involved such that the strict application of the provisions of this chapter will deprive the applicant of the reasonable use of the property. Staff finds that parking can be relocated to the interior edge of the existing pavement with a drive aisle located adjacent to the side property line, and carports are erected on the relocated parking outside of the required building setbacks. Current regulations were not in place when this property was developed. However, the property currently conforms to adopted setback standards. The requested variance is based on a hardship which we feel is self-imposed. Staff does not believe this request meets all of the review criteria and therefore recommends denial. If the Commission does feel inclined to approve the variance, staff recommends that a variance to Section 21-64 be limited to a side setback variance only, and then in the required front rear building setback lines be depicted on any future plats. And I can answer any questions.
Please,
Yeah.
please. Okay, I drove over there. I'm not sure what you mean. How's the hardship self-imposed, and then how could this be done so where it is legal?
So if you see on this picture, the parking spaces currently are to the outside of the lot.
Yes.
Bring them to the.
So what we were implying is they could switch it to where the parking spaces were on the inside, the drive aisle was on the outside, and then have the carports over those parking spaces.
I would actually put the parking spaces closer to the apartments, wouldn't it? The residents. Residents would probably like that. I don't know.
Okay, and then let me ask you this question. If all 5 items of the variance request are not met, according to this, that's not met, can we legally approve the variance?
Planning Commission just needs to make a finding that it meets the criteria. So you would just say that you don't believe it, that you don't believe it's self-imposed or whatnot.
Okay. All right. Essentially, okay, I got it.
That's the only one.
What, number 2, Ms. White? Yes. Does anybody have any questions of Mr. Charles?
Is there a reason they would not want to move the parking spaces to the interior?
The applicant is
you
here.
would.
Why,
I would let the applicant
if
explain.
anybody
You're gonna
has
lose, you may
any,
lose a few spaces. Can,
you can please
Yeah.
come forward, state your name and your address, and,
Nancy Garner. My address is 2715 Houston Highway. I own the management company. We have utilities, reroutes of utility lines, which I did answer for someone, that run out into the parking lot where if we do have to dig those lines up, which we do have to dig those lines up routinely over there, then we're going to try to be working under a carport, which is going to be difficult. We are going to lose the parking spaces, which is a big deal over there. And in addition to that, the biggest hardship of all is prior to the purchase of the property by the current owner, I'd call the city, ask if we needed to do anything, gave them the plan that we were going to build the carports over the existing parking spaces, was told that was fine. I said, is there anything we need to do? No. And so it's a loan requirement. So not only is it going to be a problem for me, but they're going to call my loan due, which is a real hardship. So we have plumbing lines, loss of parking spaces, and a loan liability that I can't meet. So what we did do is cut the number of parking spaces down. We have 90 units over there. We cut the number of covered spaces, which we're trying to do it as a benefit for the residents. We put them all over on the south side, so there are very few houses impacted. Whatever Twin Fountains built, the building that some of these will be right in front of is only 7 foot away from the building line. So part of them are going to be backing up to this metal building that's already close to the building line. The rest of it is parking lot, so.
Ms. Garner, I couldn't see that drawing that well. How high is the carport? Because I know on that one side, that fence is what, about 8 feet high?
They'll be about 10 feet.
Okay.
So.
Somebody I know on that one end, like you said, at the south end, there
So
are
we,
some
so
homes
we,
that butt
so
up
like I
against
say,
it.
on the north side, we just completely did away with them. We put them only in the back end on Abbey Street, so it's just a vacant lot back there. It's nothing but parking spaces for putt-putt, be up against Twin Fountains building, another vacant lot, and there are very few houses back on the Abbey Street side that would have a carport that would obstruct their view or anything like that. But it's going to be very hard to work on those plumbing lines, and if necessary, I can give you a history. We've had to dig up, I don't know, plumbing lines 20 times over the last 3 years. So it's not uncommon, and I don't know why they were rerouted. That was out into the parking lot. That was before my time, but the fact is that's where some of them run.
And Ms. Garner, the plumbing lines are closer, I'm just trying to understand, plumbing lines are closer
We have
to the
some lines that
apartment.
extend all the way out into the parking lot, and I like I say, I can't tell you why. can't tell you why they did that at the time, but it's apartment construction, so I run into a few things.
They would be slanted toward the outside of the property, correct? To the property line?
They're going to be slanted to the inside of the property. They have a slight slant to the inside of the property.
So drainage would go inside.
The drainage would
Okay.
come
Go into the
property,
parking lot.
Yes,
Not to the property line.
that's correct.
That was my other concern, that, because you're taking rain that normally is curbed and guttered out, would now be going to the neighbors. But it's not, it'd be going the other way, okay.
Anyone have any questions? Any other questions of Ms. Garner?
So you're wanting to cover every parking space that's there, correct?
Well, we ended up putting 70 just on the south side. Like I say, we did away with 16, requesting 16, and moved them all to the south side, so there'd be as few houses as possible, backyards of houses that could potentially be impacted.
Here, can I ask a question regarding, when they propose to do this, would the homeowners be notified? Have they been notified that this is in the works?
It's part of the variance, they would have, it's part of the variance notice.
Well,
they would
I'm just
receive.
curious, if a homeowner felt impacted in such a way that
Then they could
you
have-
opposed, then they would
The homes-
certainly be present.
The homes
I
on
would-
Tampico and,
Everybody within 200 feet.
We
Okay.
got it appeared to us that they had been notified
Yes,
through a list.
So yes, everybody that is adjacent,
Okay.
directly abuts the property would have gotten the notice.
I guess I kind of question why the staff thinks this is self-imposed from the standpoint that if this property was constructed prior to the time we had any requirements for plating, and, obviously the parking spaces are where they'd been, and if you add to it the fact that they do have issues with moving them inside because of plumbing, I mean,
And you
I
can't
would be
move
in
them,
favor
on the
of-
other side, you can't move, well, I guess you
You wouldn't.
can, but there's a fire hydrant, we have a gas
you
main,
get fire lines,
all
gas
kinds of
lines.
things. So we completely did away with that side, trying to, because you wouldn't want them on the inside on one side and the outside, so we just
well,
said.
you couldn't block the
we're
easements
so-
anyway.
It's all of that, yeah.
Because normally, if this had been met, if this had been platted in the first place, you'd have easements set out, you'd have all kinds of, which they obviously don't have now. And that's probably why some of the plumbing and everything was put wherever it needed to be put, because you weren't platted from the beginning. I mean, that wouldn't happen today.
Yeah, and I don't know how many more lines are out there, we don't have any plans from
Right.
back then, so we just have to start looking and find them as we go.
I mean, assuming that no one has come up to oppose this, I wouldn't have any problem with the variance personally.
Does anybody else have any comments or questions for Ms. Garner?
would it affect future use of this property if, say, someday these apartments wanted to be, if they were to be torn down and something else built, and we've got this variance there, or
The variance would be shrinking the building line to 0. So once it's platted, that side building line is 0 or whatever it's going to be on the plat forever.
Well, but if someone were to reconstruct something else, they'd have to come in and replat it, wouldn't
No,
they?
ma'am.
No,
Once
ma'am.
it's platted, unless they were going to subdivide it into
To other-
more than
other
one,
portions.
more than the one lot or 2 lots, however this is going to
I'm
work.
just saying, like, 10 years from now, if they wanted to put townhomes here, demolish the apartments and put townhomes, there would be no easement there.
There'd be
Right.
no building line.
There'd be no
building
building
line.
line on
Yeah,
that
no
side.
setbacks.
Likelihood of that.
Unless they were going to divide it up and individually sell the townhomes where they're on individual lots, in which case they would replat, and yes, they would have new building lines put on it then, but
Yeah, if they were going to build separate townhomes, they'd have to
Right.
have
Or whatever,
replats.
if they want to demolish it and build
demolish it,
whatever.
put a commercial building, they would be allowed to have that 0 building line on the south side or both sides.
Both sides.
Would be
That's
there.
what I'm looking at, is implications 10 years from now,
Sure.
15, 20 years from now, if we decide to give them
That's part of why
Zero lot
staff said if y'all are inclined to give them the variance, then let's keep the building lines on the front and on the back, so at least there is some building line that conforms to the ordinance for the future.
On the front and the back, okay.
That would keep the established building line across the front at least.
I'm
The
good.
one other thing I will say, and I don't know if y'all can answer what it is, that it does say, and this may have some benefit for future, or for bringing things back in line in future development, on that south side border that we're talking about, and I don't know who's underground cable, but there's a sign there on both ends of our property that says underground cable right there. So I don't know if in future, I don't know if that would help later
Well,
on.
that's probably private, one of the private utilities,
Okay.
and not, it's not a
Yeah, I don't
city
know.
line, so.
There are no public easements currently across this property, so all of the lines are private service lines.
Which is why people don't know where they are necessarily.
Right.
They probably haven't been marked.
So there would be no easements in the future.
Let me ask
either.
this, could the variance be granted specifically for the construction of these carports? And nothing else? I mean, why not?
Because it's a subdivision, I mean, we don't believe so, because it's a subdivision variance to building lines on a plat and not tied to a building permit. So once you file that plat without an absence of the building lines, then it's a legal platted lot. And we don't have a mechanism to require replat when something
Right.
gets demolished and then rebuilt. If we were a city with zoning, then yes, but not through the subdivision ordinance.
I think I can speak to that.
Please.
Normally, the easements are, like she says, they're on the plat, and so when you're all platted, and I guess this has to do with how the county, you should know this, Mary Ann. The county keeps its record.
Right.
When you file a document, they're in the county records according to the legal description. The plats are kind of in a different area, and it's hit or miss whether you can catch those or not. If this is filed as a separate document in the line of succession for the county, so that anybody who's searching the title can see this variance. If it ends with ownership or demolished or whatever, it will be in the county records, and they will find it. So you could make a finite, it's kind of like a life estate. As long as this apartment survives,
The variance is, I mean, I don't see why we couldn't limit it. And I agree with you, it'd have to be filed in the real property records. But
Would that be like considered a deed restriction at that point, or?
It's almost like,
similar to one,
Similar to a deed
yeah.
restriction?
It'd be a Schedule B item, like on the title policy,
when we do the
Okay.
right?
did you plat it with the building line? Ignore the- I know, but what,
Correct.
what if you
I like that.
drew the, plat, you put the
Would be on
numbers
notice.
on it, and the variance was just built over the building line,
call it an easement rather than a variance.
just for the carport that one time?
It will end.
Is there a way to like twist this to where it is just,
Plat first and then.
So,
and then give a variance
no,
to the
that,
building?
that makes,
Especially for someplace like this.
what is it?
I don't know.
That has been there for.
Forever.
It's an interior lot that was built, I don't know how long ago.
When nothing else was there.
Everything's changed and whatever. If you want this to be finite, you can do that.
So can we,
So what,
Can
would it
we-
be a different section?
Pardon me?
Would it be a different section than what we notified for though? Because wouldn't it be the development setback section instead of building lines required on plats section?
That I don't know.
so we
I'd have
could,
to look, and I'm not
I guess one of our
sure.
questions is, if they platted it and it had the regular 10-foot building line on it, or whatever the building line's gonna be, I guess it'll increase to 20 where they're single-family houses. But we gave them a variance to build over that platted building line, then that would achieve where it's just this one time, and if something happened, the place burned to the ground
I
or
would
redeveloped, it
rather
would build
see
to
them
the
plat it with the building lines, and let's give them a variance to
I
build
don't
over
know
the
that we
building
To
would
line.
build over the
notice
building
the
line.
right section to do that, but that would be one way to do it. You know what I mean? Plat it or where it meets code, but then we variance the building permit to be able to build over the the newly platted building line.
But actually,
Whatever's easiest for you, and that you're sure it's in the property records, so that if and when this place is burned down or sold or whatever.
Somebody
We're
would be
also
on
assuming
notice.
That's gonna happen, let's hope not.
language.
Someday it may get redeveloped.
If I don't get this variance, I'm gonna have to do that because I don't have $2 million to, after I get my tail sued off by my client.
You could even put a note on, I mean, I agree with you, something needs to be filed in the official records, but you could even put a note on your replat to the effect that a variance is being granted for
And
building
building
over
lines.
In a
the,
separate document, and you need to reference that separate document, because
Okay.
Right.
you've got to keep them connected. If they're not connected somehow.
I would be
and
more
somebody
inclined
oversees
to
then
approve it
you're signing.
being platted with the building lines and then a variance to build over those building lines.
Okay.
That way the building lines are part of the plat for future reference, for future use.
but it
in the
takes care
event-
of their problem.
Right. And that solves their problem and it protects future owners.
Okay.
How that would be worded, I have no clue.
No,
Or
It'll
how
be-
we
it'll
can
be a totally
accomplish
different
this.
variance.
yeah, but you think it's still achieving the same
It is.
thing, playing with, from a property owner, still allowing the carport to go where it's going.
Well, I think we just
If
noted
you
a
make
setback
the
variance to
finding-
carport.
But y'all have to make findings. It's not up to us or the
Right.
planning commission.
I understand.
It is up to the planning commission. It's not up to us or the department or whatever. Y'all have to make separate findings so that it's in the records, and you can put that in the document itself, and then it goes in the county records, and it will live until they die.
Right. That's why I think it should be platted to meet code, and then we can give them a variance to build over those building lines. Because then if those carports ever go away, they would have to get another variance to rebuild over the top of them again.
Correct.
If a hurricane were to come through and wipe out the carports, okay? And then a new owner says, well, we want to build garages now. Single-car garages like some apartment complexes have.
They
Then the-
couldn't.
No, the easement will die.
Once the carports are gone.
Right.
Yeah.
That's what I'm saying. Then it would have to be, they couldn't otherwise there would be no building line there, or utility.
Unless you sold it to somebody who didn't go through the bank or a title company or whatever, and they just.
Well, the plat's still going to show it, though. The
Right.
plat would still show it. Anytime they would apply for a permit to build, that building line, setback would still be there on the plat, and would have to be addressed before any other permit could be given again, correct? Okay, I'm good with that.
It has to be in separate, it has to be in a separate area in the class. It has to go, it has to be a separate.
Separate document that could be filed.
Any idea how we get this done, Jerry?
Somebody's
I
got to
think
make
we're
a
all in-
motion with the correct,
You have to make the findings so that this is allowed, and that's y'all's decision. That's not.
Well, we have to make a finding
So we have to
that,
find that the hardship is not self-imposed?
right,
And you can.
that it meets all the 5 criteria
You
for a
can say that it
variance.
meets all the criteria, that you don't believe it's self-imposed, but you want to impose the conditions that we're talking about, that they plat the property with all of the applicable building lines, but we're going to be instructed to issue a building permit specifically for the carports only to, over that building line.
And it be filed separately in the official
And we'll
records.
file separate records so that they tie the plat and the,
move to approve.
So moved.
So it's really not.
I know.
Ms. Foster?
Can we do it like that?
What's
So
being
it's building-
proposed?
building lines.
I will have it in
This
the
one.
recording.
Yeah.
Translate it.
And I just absolutely.
when we go to council, we'll change the variance to that.
Oh, no.
Yeah, right in the middle of all that. We'll do that. But it's in the recording.
I don't see where the hardship is
Self-imposed.
based solely on the cost of complying. It's not the cost of it, it's the safety of it with the utility lines and what have you as well. So I don't see it's just solely on the cost. There's not just solely on the cost, it's also other factors.
So this is in this.
You want to do it in separate motion?
Well, I'm not
Like
really even sure. So first of all, I was gonna wait and see what they come up with.
Well, I think first of all, we make a
They're in the
motion
huddle.
that we believe that the variance meets all 5 requirements, which is saying that it's not self-imposed.
Okay. Are we sure about this?
You can have it.
Let's ask them.
We're real close.
Well, I know we're all in agreement, but let's just make sure the language is correct.
Okay, so you have a motion and a second to do what we're talking about, correct?
Correct.
What-
You all understand what we're talking about?
Audio,
It's
yes.
it's to allow setbacks in accordance
Well, we,
With the
ma-
Variance from
requirements.
section 2182G.
2182G. I'm looking at Lila.
I thought it was the 2116A we're supposed to make a finding on.
Well, that's what you're going to make findings on.
Yeah, the same amount.
So should that be the first motion?
Sure. Make,
we have, well, all right. All right.
Okay,
Somebody make
I
a
move
motion.
that we find that the variance request meets all 5 criteria under section 2116A.
okay.
2164. Okay, 2160. Okay, so we have a motion before the commission that the variance meets all the review criteria. Ms. Wyatt made the motion, Mr. Koenig seconded. All those in favor say aye.
Aye.
No opposed. So the review criteria, our variance pass?
No,
No.
well, you said that you've changed basically to say the review criteria, it meets it.
Okay.
But I think we ought to have a separate motion that clearly says,
You're granting a variance to 2182G.
which means that they're going to plat the property
And
with
allow
the
construction over
the
the
current
building.
applicable building lines that'll apply to that property. And then we're going to issue a permit that allows them to build carports only this one time over the building line. That's what I
And
understood y'all were asking.
file that in the
And we'll
official
file
records.
a separate document in the document records that ties the plat and the rest of the property records together.
She moved to approve
moved
that,
it.
and I believe Ms. Welder seconded that.
Yes, that's fine.
Yes.
Okay.
All in favor say aye.
Second.
Aye.
Aye.
Okay.
Okay, sorry.
Now,
that-
how is Ms. Garner going to know what to do here? And all of
I know what to,
I would just leave quietly.
I think I know what to do, and thank you for
Okay.
your consideration.
It's just to go to council.
Yeah.
We'll make sure that the resolution-
Yeah, this is good. Thank you for your help.
Sure.
Thank you, by the way.
Nancy.
Thank
I
you,
think that's,
Ms.
I think it's a
Champion.
lot.
She helped us.
Yeah, because
So-
it does keep in line the deals for the future.
This will not work with all the variances that come to pass, so just please realize that this is a unique situation. This is not the end of every variance.
Right.
Yes, ma'am. So noted. Is that it for that one? Agenda item D1. Okay, we're good. Go ahead, Mr. Charles or Mr. Mayfield, whoever's going to do D2 here.
Okay. Now that we've got that one out of the way, a little more complicated than I would have thought that would be, but anyway. All right, so tonight we have 2 text amendments, subdivision ordinance amendments for you to consider. The first is related to off-street storage and display, and I really ought to let Julie introduce this one. And then the second one is related to screening fences, and that's the one that I probably can explain better myself.
We probably should have broken these into 2 separate staff reports since we both worked on a separate one. So currently, our regulations state that all motorized or storage or parking of anything that's motorized, equipment, vehicles, anything that has a motor on it, boats, is supposed to be located on a paved surface, which is, concrete or asphalt. And as you drive around town, I'm sure you can see that there's a lot of exceptions to that regulation, mainly because a lot of developments were done before our current regulations were in place. So it's become very difficult to really enforce through the site planning process. Especially whenever you have large equipment and industrial type uses that with backhoes and other type of things that do have motors that could potentially tear up concrete and is being worked on in a sort of a yard, storage yard, pipe yard, whatever it may be. And so the intent, I think, is to really make our city aesthetically pleasing and we don't have, for example, car dealerships parking all of the cars on gravel road or gravel base parking lot. So that's, as I said, why I think the intent of the regulation is to have anything with a motor on concrete or asphalt. But in practice, it's just very expensive and it doesn't work very well. And I have some examples. So this is a fairly new development. As you see, we do require concrete driveways and shake-off areas. And so this is a traditional just storage yard that doesn't appear to be any sort of motorized vehicles being stored. And then this is a very old development that you can see is mostly a parking lot for this like industrial type use. So what we're proposing is to separate out the storage and display of items or vehicles. So if a industrial type use wants to store items or store vehicles, that storage could happen on something that's not a paved surface, so gravel or, whatever type of surface that they is not basically concrete or asphalt, but it would have to be behind a screening fence and out of the setbacks. And so it's a huge cost savings for a very industrial type business without having to do all of that concrete. But then it still protects the streets with it being set back, and you have, of course, the required pavement on the driveways to prevent the runoff of gravel and debris such as that into our public streets, and then also provides a visual barrier from our rights-of-way with the screening fences. So that would be the regulation for displays. In exchange for concrete or asphalt, you would be constructing a screening fence and then locating it behind the building and out of the setbacks and a little bit farther into the interior of a lot. Then the flip side would be the storage of items and vehicles. And display. I think I got that mixed up. I think you know what I'm trying to say. Storage would not have to be paved, and display, which you would have customers coming to that display area and customers, driving or walking on that different area, and we would want that to be paved, and it could be in front of the building, close to the right-of-way, so we wouldn't have to worry about debris, and it would be more aesthetically pleasing as you drive through our corridors, and so that the two. We're separating out the regulations for a regulation of display and a regulation of storage with this proposed text amendment.
So you understand? So if it was a tractor dealership,
I was going to say, yeah, tractor dealership.
like a tractor dealership's a good example. So they're obviously selling some of those tractors. The ones that are on display for the public to look at, touch, feel, whatever, those would need to be on a paved surface. But the parts and, maybe surplus tractors or whatever could be on an unpaved surface, just, a gravel base, back behind a fence, back behind the building or whatever, and they wouldn't have to pave that entire area. We've been kind of working our way through that. There's a bunch of kind of oil field related businesses in town that have gone through site plan where we already have this. We've been requiring 100 feet of paved surface in order to shake off dirt and mud and gravel and whatnot. But it's never been just very clear in the code of how we apply that. So that's part of what we're doing. And it's actually making it more flexible. You could even translate this to golf carts or something.
Well, and it ultimately makes it cheaper for the businesses.
It does make it. It makes it less.
But you can also see the results of it if you go out 59 going towards Goliad.
Mm-hmm.
As soon as you cross the first underpass there on the right, there's the oil field business there, and they're constantly coming out there on 59. Right
Sure,
past
you've got
Oak.
that mud, you've got
And
that
there's
dirt
mud
track.
always out there on 59. Now, that's out in the county, I understand.
But that
is
that
what
was
you're
happening.
trying to prevent.
Yes, sir. And that was happening in the city years ago, and so
Right.
this rule was put in place to deal with those. But it's not practical where you've got acres and acres of pipe yard or whatever, or some bunch of heavy equipment being stored. You could have a construction operator, something's got a bunch of heavy equipment. It's not for sale. It's not on display for the public. But if you read our ordinance to the letter of law, it would require them to pave all of that, and it's a little bit ridiculous when that heavy equipment would constantly tear up their paved surface. So that's what we're basically asking to clean that part of the code up, and it provides a lot more flexibility for those types of businesses.
So for the examples, in this picture, it would basically be the same type of development, except instead of a chain link fence, it would be a privacy fence, and it would be set back 25 feet. In
Is
this,
that what, I'm sorry.
no, it's okay.
What do you mean by a screening fence? Is it a
Privacy
wood,
fence.
Or
a
Privacy
wood
fence.
fence?
Oh.
It could be, what's that?
Or the cloth screening,
Yeah.
Cloth
we
screening,
put-
anything.
we use-
canvas.
We we define what a screening fence is elsewhere in the ordinance, and it is typically a opaque sort of wood. There's materials that is outlined in there, but this code also allows the alternative screening materials to be subject to the approval of Jared, Director of Development Services. So if someone wanted to maybe propose a screening hedge and use some vegetation instead of a fence, that's something that could be entertained.
And that's only just for the aesthetics. It's probably a more industrial type application, and so you're not looking at, that's the purpose of the screening fence, right?
Right. And in this second example, if this was developed today, we would require enough parking for employees or customers in a parking area, but again, it would be farther, 25 feet back, kind of where the screening fence is, that's existing. And if those are fleet cars, that are being stored, then they would not
For your industrial type settings,
paved.
when they're having tandem or triple axle trailers and what have you, turning those on concrete or pavement, you snap axles, and that's not good. So gravel is good for them for the heavy equipment. They have.
And this would allow that.
Yeah, this would allow that, so that's a good thing for them, definitely. 'Cause if that will be able to promote more industrial development, that would be a good thing. Okay, I'm good.
Okay, and the last one, as we said, was dealing with screening fences. And this picture gives you a good example of, I know this screen's kind of messed up, but the screen that's over Lila gives you the full picture. This screening fence is built exactly to code. So it's when you have a commercial business adjacent to single-family residential, the ordinance requires an 8-foot screening fence. So we've got this is the Twice Blessed and then one of the old homes behind it. So they had to do the 8-foot fence. Then when you hit the 20-foot building line mark headed to Main, you're supposed to, in the middle of that, transition down within a 5-foot stretch, a real sharp decline, and then we have a maximum height of 3 foot of fence when you're inside that 20-foot building line in order for cars to be able to see oncoming traffic and whatnot. So what staff's wanting to do is tweak this just a little bit and require that 8-foot fence to go a little bit further and then allow for a more gentle transition so that your screening fence isn't going from 8 foot to 3 foot in such a short place. It would provide a more gentle slope that I think would be more aesthetically pleasing and provide a little more privacy between and screening between the single-family residents and the commercial business. So it would basically move the privacy fence 2.5 feet over and then provide a longer transition period. So anyway, a little more 8-foot of fence between the commercial business and the house. It's a real minor tweak, but I think it'll provide for more aesthetically pleasing. There's a bunch, if you start looking at some of the screening fences in town, there's a bunch of them that have been approved by our office that don't match the letter of the code. They transition down. Sometimes they go all the way down to the front property line and they transition down. They've been transitioning down for 15 to 20 feet, and that's not the code. But this is kind of ugly.
Well,
So,
it definitely improves the historical district.
yeah. So,
Sorry, I had to throw that in there.
Yeah, just
I mean, that is,
He's not being good.
I'm not being good. but-
not being good.
Yeah, I mean,
Please go
anything to
ahead,
make,
Jim.
anything to make that more aesthetically pleasing than what it is, yeah, I could see
Yeah,
that.
I don't see that as much of a cost increase. It'll, in fact, this is not what was originally built out there. They built something that had a more gentle slope and whatnot, and one of our newer inspectors said that doesn't meet code, and
Made them change it.
made them change it and cut it down. And then once I
Now it
saw it, I
looks
was like,
ugly.
that is just as ugly as I'll get out, and we need to look at the code and fix this. And we were already coming.
So is the city gonna reimburse them for taking it back the other way?
No, sir.
Just curious.
And there's a bunch of them in town that have been built correctly like this, and so, but there are others that haven't. So, and I know that their fence contractor didn't charge them to cut it down. We were out there.
Good thing.
Anyway, so since we were already coming to you with the off-street parking and display, I decided to try to bring this one to you and see if we couldn't get it cleaned up a little bit too, make it a little bit better.
Now, my question would be, is something that she mentioned earlier on screening fences while we were addressing this ordinance. Possibly using vegetation. Is that something that we would look at in the future there?
No. Now,
hedges?
now there is an option with this particular code. You know, if the residential property owner didn't want the 8-foot fence or didn't want a fence at all, they can sign a waiver, and then the commercial property owner doesn't have to sign it. We typically see some of those waivers signed, and people just agree to reduce it down to 6 foot, which is a standard residential fence. So that's frequently that's the kind of waiver we see. Or they're just the property owner, the residential property owner is agreeing to reduce it down to 6 foot for air
So when
circulation
people
or whatever.
apply for their permit to build this, are the adjacent neighbors notified that they have the option of reducing it down?
The option is actually, no, sir. The option is at the commercial property owner's discretion to choose to do it.
So we don't give the adjacent property owner the option to sign the waivers, hey, if you want to, you can bring it down?
Right. It's at the, and usually, you know, the commercial property owners are going to the residents because it's a savings and, you know, fence costs to reduce it from
Right.
8 to 6. But the way it's
In a
written.
case like that, a 6-foot fence would probably be a lot more aesthetically pleasing for the property owner next door.
Possibly. I know at least one of the property owners wanted the 8-foot fence.
Yeah.
on the-
They don't, okay.
I don't know about this one, but
Interesting.
Yeah, no, it's good.
any more
I have no
questions about either one of those?
Anybody else? Nobody? Do we have a motion?
We need to have a public hearing even though there's
Oh,
no one in the audience, just for the record.
all right. Any public hearing request? No. All right. Do we have a motion before the commission to approve the language changes?
So moved.
Second.
Okay. All right, so we have a motion from Mr. Woods and a second from Ms. Welder regarding the revisions. All those in favor say aye.
Aye.
Any opposed? No, so approved.
All right, very good. Last thing on your agenda is the monthly development report. If you saw that in your packet, received 2 minor plats this past month, and we did 4 site plans for a new discount tire over on the south side of town. For those of you that remember the awesome paging site, this is vacant land next door to that, across from the Walmart South. A new cell tower on North Street, out near 59. I think this is the second version of a site plan we've seen for Victoria Honda for their proposed dealership out there at Navarro and Huvar, across from the Holiday Inn Express and Hilton Garden Inn. And then the Office of the Attorney General is building having a new building built behind the Homewood Suites on John Stockbauer. And then building permit activity, we're kind of moving steadily along, still seeing 10 to 12 houses a month being permitted, and you should see we did $3.4 million in construction last month. So kind of, now that we're near the end of the year and the holidays, it's continuing to slow down. But that's usually, other than that, it's 2013 when we were doing apartments and hotels every other month. This is more typical for us. So, any questions?
Does anybody have anything you want to speak to the commission? Any comments from the commissioners? Nothing? Great. Do we have an adjournment motion?
Motion to adjourn.
All right, we have a motion before the commission by Mr. Woods, second by Ms. Wyatt to adjourn. All those in favor?
Aye.
All right, great.
Sorry I'm late.